Welcome, everyone, to the 2021 Constitution Day celebration of Tulane University and Tulane Law School. My name is Sally Richardson. I'm the Vice Dean here at Tulane Law School, and we're excited to have you with us for this Constitution Day. The birth of Constitution Day dates back to the signing of the U.S. Constitution on September 17, 1787. In 1952, the U.S. Congress passed legislation commemorating the formatting and signing of the Constitution on September 17th. In 2004, Constitution Day became more than just a commemoration, but also a day of education at the behest of late Senator Robert Byrd from West Virginia. Having met Senator Byrd many times when I myself worked on Capitol Hill, I can attest that Senator Byrd always kept a pocket copy of the Constitution like this in his jacket pocket and discussed our founding document with everyone, from constituents visiting his office to colleagues on the Senate floor, to even the eager young staffer like myself who happened to catch his ear. Based on his love of the Constitution and his steadfast belief everyone should learn more about the Constitution, he included in the Consolidated Appropriations Act of fiscal year 2005 a provision that all educational institutions must provide educational programming on the Constitution on this day every year. Perhaps Senator Byrd's procedural maneuver to include Constitution Day in an appropriations bill is even more poignant today, given how budget reconciliations and appropriations bill have made such mainstream media news. This year's topic for our Constitution Day is also quite poignant: voting rights and the Constitution. Who can vote in this country is an issue as old as the Constitution itself. As the panelists will no doubt discuss today, the right to vote is a vote that has morphed throughout our country's history and continues to be a topic of mainstream discussion. Over the past 4 years, state legislatures across the country, and most recently the U.S. Congress, have offered a record number of bills regarding the right to vote, and in turn, a record amount of litigation has been filed challenging different state legislation. Our panel today is on the forefront of that litigation, serving as lead counsel and policy advisors regarding the fundamental right to vote. And with that, let me introduce our panel. We're excited to have with us today Allegra Lawrence Hardy, who currently serves as the lead counsel for Fair Fight Action, an organization that seeks to promote fair elections across the country, encourage voter participation, and educate voters about their voting rights. Allegra is a graduate of Spelman College and Yale Law School. After graduating from law school, Allegra clerked for the Honorable Susan H. Black of the 11th Circuit Court of Appeals. She has spent more than 2 decades of her legal career as a top litigator, working in areas of business and commercial litigation, labor and employment issues, and crisis management. She is a founding member of the firm Lawrence and Bundy, and in addition to all of these accolades, Allegra became a household name when she served as the chair of Stacey Abrams' 2018 gubernatorial campaign. Joining Allegra on this panel and at her law firm is Tulane graduate and now Tulane Law School adjunct professor Celeste Coco Ewing. A graduate of both Tulane Newcomb College and a summa cum laude graduate of Tulane Law School, Celeste began her legal career by clerking for the Honorable James Dennis of the U.S. Fifth Circuit Court of Appeals. Celeste has multiple decades of experience as a seasoned litigator focusing on complex litigation with an emphasis on product liability and toxic tort cases. New Orleans resident, Celeste practiced at Stone Pigman and Barrasso Usden before recently joining the Lawrence and Bundy firm and the Fair Fight Action litigation team. We're also very lucky here to have Celeste as an adjunct professor teaching depositions practice for us as well as evidence. Rounding out today's panel is the Reverend James Woodall. A native of Georgia, James graduated from Georgia Southern University and then received his master's in divinity at the Interdenominational Theological Center. James' service to the country is well noted, having served 8 years in the United States Army as an intelligence analyst and having served on the state committee of the Democratic Party of Georgia. James made history by being the youngest person to serve as a state president of the NAACP when he was elected as president of the Georgia NAACP, and he now works as a policy associate at the Southern Center for Human Rights. With all of that, let me turn this over to let our panel get started talking about the important issue of the day, namely voting rights. And so, Celeste, I'll turn it over to you.
Well, thank you. And I want to say thank you to you, Dean Richardson, and to Tulane University on shining a light on this incredibly important issue. I am honored to be here with Allegra and with Reverend Woodall, who have really been in the depths of this issue and doing the hard work for the last few years. As Dean Richardson mentioned, I've recently only joined this work. So because we're here on the Constitution, I wanted to give a start with just a 1,000-foot overview of the key constitutional provisions that are in the Constitution. So hopefully you can see this. And most of them, as you can see, are amendments. There's the 15th Amendment, which secured the right to vote for all people, regardless of race, all men, race, color, or other such preconditions. And that was in 1870 when the Reconstruction happened following the Civil War. And then the 19th Amendment, which was only shockingly a little over 100 years ago, which gave the women the right to vote, including me. The 26th Amendment, which was following the, or as part of the outgrowth of the Vietnam War, which secured the right to vote for people who were 18 years old. Previously was 21, and the argument very validly was, well, if you're old enough to go to war for the country, you're old enough to vote. Now, I also have added here the Voting Rights Act of 1965, which is, I believe, the most important outgrowth of the 15th Amendment. It's not a constitutional provision, but it is, it was enacted by Congress as a result of the 15th Amendment's authorization to Congress to enact laws. So with that very high-level overview, I now want to just start a discussion, Allegra, by calling on you. You and I have had a couple of discussions over the last week about the importance of the right to vote for all Americans and how the right to vote fits into the other rights that we have as American citizens. And I wonder if we could just have you speak on that a bit.
Absolutely. Thank you, Celeste, for the question. And thank you all so much for having us here today. The reason we at Fair Fight Action have been so focused on voting rights is that voting rights are the rights that allow every other right to be enforced that we have under the Constitution as American voters. And so whatever your issue may be it education, healthcare, poverty, et cetera, the list goes on and on, voting rights are essential for ensuring that we have a democracy that absolutely accurately speaks for the people. And that is why when you have the sorts of practices that have been involved in really discouraging voters and suppressing the vote, that you have a real threat to our democracy.
That's great. So if you care about climate change, you should care about the right to vote. If you care about abortion, whatever side you're on, if you care about it, you should care about the right to vote. If you care about who's on the Supreme Court, you should care about the right to vote. So it's such an important right. The other thing that I mentioned kind of at the top, or has been mentioned by Dean Richardson, is just about the timeliness of this discussion on voter rights. But really, if you look back over the history of this nation, this issue was timely in the 1800s, it was timely in the 1900s, and it is timely now too. So I'm wondering, Allegra, if you could just bring us from the 15th Amendment and give us a little historical perspective.
I can, Celeste, although this is one of my least favorite things to think about, is how long this fight has been going on and how much work remains to be done. But it's also why I'm so excited to be here today, talking with this next generation of the people who will really be required to finish this work. Right? We always say we will run as long and as hard and as fast as we can, but we've got to pass the baton on because there will be so much work to do. So just to put this in context, for those who haven't thought about the path from Reconstruction to where we are now. But Celeste, you talked about the 15th Amendment being ratified in 1870, giving Black men the right to vote. Immediately after this, we started to see record participation by Black voters for the first time. And in the 1868 presidential election, there were more than 700,000 Black voters. More than 700,000 Black men voted. There were, in many areas, 90% voter participation rate amongst Black men. And as a result, some 2,000 African Americans held public office from the local level all the way up to the US Senate in Reconstruction. And in all, 16 African Americans served in the Congress during Reconstruction. Excuse me. So incredible numbers. Well, that didn't sit well with everyone, obviously, and that was a large part of what ushered in Jim Crow. In 1877, we start to really see these Jim Crow laws get rolled out. And in addition to obviously quite graphic examples of physical intimidation and violence, you also saw Jim Crow laws rolled out at the ballot box, causing a dramatic decline in the political participation and an increase in disenfranchisement of these Black men who had really just begun to vote and feel their political power. And we all know now what types of activities those were, right? We know about grandfather clauses, literacy tests, all white primaries, all methods that burden the right to vote and really cause a dramatic decline in African-American voting. As a result of this, between 1901 and 1929, no Black representatives or senators served in Congress at all. And in the 30 years that followed, only a dozen more African-American representatives were elected to Congress. And it took until 1966 for another African-American senator to be elected to the US Senate. Why do we care about all that now? Why do we care about that now? Because we've just seen the exact same thing. And that's what we really want to make sure people appreciate the historical perspective on. Voter suppression of people of color continued from that time in 1966 into this present day. And despite the 15th Amendment, Black and brown voters have been oppressed and suppressed, often through intimidation, but also through laws. Obviously, we're all familiar with the many civil rights legends who have worked to really secure the right to vote, but we also know that following record participation by Black and brown voters in the 2020 presidential election, we've started to see again, just like we've seen in this country in the past, a rollout of laws and tactics really designed to disenfranchise Black and brown voters and to suppress the Black and brown vote. Celeste, it has to happen in every panel. I think you're on mute.
I'm not on mute. Okay, the host had done me. I'm sorry about that. Well, thank you so much for that, Allegra. And there's a lot to unpack in that. And one of the things I wanted to make sure that this audience got to hear about are the recent Supreme Court cases that have come out and how they might impact these laws that you talked about that are being proposed. And I wanted to start by talking about the decision in Shelby County versus Holder. And that was a 2013 decision. Chief Justice Roberts was the author of the decision. And that had an impact on a part of the Voting Rights Act, the Section 5 of the Voting Rights Act, which, well, maybe you probably are better able to explain Section 5 than I am. You've been dealing with it longer, but I'm happy to. Yeah, so Section 5 there's a formula that, well, I'm gonna let you, Allegra, please.
So look, the Voting Rights Act, without over-lawyering it, knowing we're having a mixed audience of students from different disciplines, the Voting Rights Act contains various provisions that really give voice to the constitutional protections around voting. And there is a lot of that in Section 2, but also in Section 5, which was has been a very important part of the protection that Black and brown voters have received. And one of the provisions that Section 5 provides back in pre-clearance days, in the good old days, as it was when I began practicing, prior to Shelby County, when a state that was covered by Section 5, and it would be covered because of past discriminatory practices, or other types of activities that would bring it under the statute's umbrella, those states had to apply for preclearance, asking the Department of Justice for permission. So for example, we have a policy in Georgia called exact match. And I'm just going to take a moment to explain this because it will give you an example of how it works more broadly. Exact match basically says if there's a problem between your voter registration and the way that you present, the ID that you present the day you go to vote, you don't stay on the polls, you come off. If there's a problem with how you're signed up in one place or another, you get put on probationary status. Something happens that bounces you from being a regular voter in good standing. Note that I don't call it the matching system, right? Everyone, of course, thinks names should match, that people should vote their own ballot, right? No one's advocating anything different. The problem with exact match is that people like me, right? You all see on the screen, my name is Lawrence-Hardy. Well, I can tell you right now that anytime, any place I go, be it the dentist, the car wash, anywhere I go, I have to give them about 3 or 4 versions of my name before they can find it, right? Some people put me under Lawrence, some people put me under Hardy, some people give me a hyphen, some people don't give me a hyphen, I get a space. There are various things people do with my name. Turns out that's—
I feel your pain on that.
Indeed, I can only imagine, Celeste. And it turns out this happens more often to women than it does to men, for example. You know who else has a lot of trouble with exact match? People who don't have traditional Anglo-Saxon names, right? So as soon as the name starts to be, I guess people will call it complicated. I don't think my name is that complicated. It's all phonetic, but I'm sure, I guess some people feel that way. As soon as the names start to be not as expected, then there start to be more issues with exact match. Again, that looks like, for my constitutional scholars out there, something that on its face, right, is benign, but in actual application really becomes quite problematic as applied to Black and brown voters, and particularly voters from other countries.
And that matches her even as a result of a typo.
Or as a result of a typo, absolutely. Which, by the way, I can't speak to your driver services office, but in my driver services office, that happens, right? And so these are the things that were going to be covered by this exact match policy. When they applied prior to Shelby County for approval to implement this policy, the Department of Justice said you can't do it. You can't do it because it's going to have a disproportionate impact on voters of color, which is no doubt the case. After Shelby County, so in the Shelby County case, the court basically said the justifications that allowed for the DOJ's preclearance requirements are outdated. There's not enough of a congressional record. And so we're going to strike them down. And that changed everything. And Celeste, I think you have a slide that will help me make this point. That changed everything, because what happened then was that individual states were free to go ahead and enact voting restrictions. And so you see the voting restrictions that were there. To the right, this is from the Brennan Center for Justice, a wonderful, wonderful resource for anyone doing work in this area. We are forever indebted to them for their excellent research. You see on the right, the voting restrictions in Section 5 covered states. And you see on the left, all the states that were covered. So many of those states, especially the ones in the South, right, had a lot of voting restrictions. Can we get the next slide?
I think that it's side by side.
Oh, okay. So if you look at the left, if you look at the map on the left, you get the states that were covered by Section 5 in 2013 when the Shelby decision came out. And then to the right of that, you see all the states who, following the elimination of Shelby, when the restrictions were no longer there and the states could do what they wanted without having to go to the DOJ, the very quick rollout of all these new policies. And you see it in these states, primarily, of course, in the South. I was going to say the Southeast, but there's Texas, nice and big. Texas, who we think so much about these days. So there you see all these voting restrictions that got rolled out again, right? Because they no longer had to go to DOJ because that's when Shelby was decided. And so Shelby really changed the entire landscape. And that's why we always tell people that judges are really important, right? That's a really important part of why we make sure we don't ever miss an election to vote, because that ruling in Shelby has made all of these restrictions possible because they no longer had to go to the DOJ. And in many circumstances, like with regard to exact match, it's the same exact restriction that they had applied for prior to Shelby County. It's just after Shelby County, they didn't have to go to DOJ anymore for approval.
Thank you for that. And Reverend Woodall, I wanted to call you into this discussion at this time because we talked, Allegra was mentioning what happened in the aftermath of Shelby. And I know as a result of being a part of the NAACP, you're aware of action taken the day after Shelby came down and a lawsuit that ensued. So I'm wondering if you could share with us that experience.
Most definitely, and thank you, Celeste, for the question, and to Lane for having us here for this timely and urgent conversation. In July of 2013, we saw, literally, after, to your point, after the Shelby v. Holder decision, the North Carolina General Assembly passed an omnibus bill. It was House Bill, I think 589 or 489, that really walked through rather some of these voter suppressive tactics. We talk about, shortening the early voting period. You talk about eliminating same-day voter registration. You talk about even the elimination of pre-registration for 16 and 17-year-olds that we see all over the nation, and other, smaller changes that all conclusively had an impact on the ability for people, particularly African-American voters, to be able to participate and vote. The North Carolina State Conference of the NAACP, the Department of Justice, and several other organizations filed a suit pretty much challenging under Section 5. I think it was Section 5, or it may have been Section 2. I can't recall which section that they challenged it under, but they ultimately said this is disproportionately impacting voters of color. And the Supreme Court agreed with them. It took all the way up to, I believe it was the 11th Circuit, and they said that you all have, discriminated against African-American voters. And one of the things that was very unique about what happened in that 2013 case was that legislators were emailing each other, literally saying, this is what we're trying to do. And so, when we talk about, standards of proof and how we are able to ensure that we protect the right to vote, those communications are important. And this is one of the reasons why we talk about transparency in these processes so much, because that way we know how these laws are coming about.
Thank you. So before Shelby, what would have happened with those North Carolina laws that they would have had to have been pre-cleared by the Justice Department? Is that's fairly accurate. And we saw, I know here in Georgia, the Holder, DOJ, the Obama administration approved, say here in Georgia, they approved our 2011 maps. They also approved the 2001 maps. And so, it's not necessarily a fix all end all, but it's a check and balance that we need to be able to ensure that gerrymandering is not taking place, that we're ensuring that these voter, restrictive changes are not disproportionately impacting our communities. And, when we look at the Constitution, everybody loves to talk about the Constitution when it comes to the Second Amendment, but when we look at how it ensures that every single citizen, and I lift up the word citizen very, very closely because we oftentimes try to exclude some portions of our community, but every single American citizen, regardless if they're naturalized, regardless of if they're incarcerated, regardless if they're poor or if they live not in the metropolitan areas of our states, but rather in our communities in the rural parts of the state, that every single citizen should be able to vote without any infringement upon that right. And so that's one of the reasons why this is so urgent. It is very timely, and it's taken literally every ounce of our being to ensure that we do not leave this moment and not be able to say we did all that we can do to protect that right. That's great, Reverend Woodall. And I wanted to just give a few highlights from that. It was the Fourth Circuit who heard that NAACP case. And what they found was these collection of practices that were implemented in this omnibus bill. They found that it was the practices were enacted, they were targeted to African Americans. And this is a quote from the Fourth Circuit. with almost surgical precision. And the Fourth Circuit found in that case that there was what had been done amounted to intentional discrimination. So, I mean, this is not just some, a few things playing around the edges here. And to your point, the right to vote is pro-democracy. Protecting the right to vote is pro-democracy, not pro any particular party, individual, race, or anything.
Oh,
yeah, go ahead.
No, I just wanted to agree with exactly what you just said. This is something that impacts all communities. And when we are able to say that everybody can participate and show up every single day and have a voice in this process called democracy, that's when America is at its best. We've seen the historical record of exclusion from the 1860s. We talk about, in words of my good friend, Reverend Dr. William Barber, he talks about it being the third Reconstruction. You have the 1860s, where you have an intentional exclusion of, African Americans who had just become free through the Emancipation Proclamation of 1861. And then you see, records and scores of African American legislators being expelled from various states in the South, including Georgia. And so then you go to the 1960s and 1970s, where now you have this new kind of framework in which we're able to protect ourselves from these kinds of restrictive changes to the law. And now you have this third Reconstruction, as Dr. Barber calls it, where you're seeing these records again. And it's important for us to not pin this all on the Trumpism, right? Because the North Carolina decision was 2013. It's almost 8 years ago, or over 8 years ago. And this wasn't the first, nor was it the last. And so if we are not honest about how we got here, it's going to be very, very difficult for us to be able to move forward as a collective.
That's so important. In the Shelby decision, Chief Justice Roberts, in striking down the formula, said that nearly 50 years later, things have dramatically changed. And he pointed to, an increase in Black registered to vote in voting. And he also pointed to an increase in Blacks serving in elected office. And I'm wondering, do you agree that let's go to Allegra. Do you agree that there's been this sea change?
So obviously, I do not. I will go much closer to Reverend Woodall's assessment, along with Reverend Barber's. And I honestly, I find this argument fascinating. You hear it a lot, this notion that because there is higher participation, that means that the issue doesn't exist. It feels to me like people are missing the broader point. So one of the reasons I got to know Reverend Woodall is because he was with a group doing incredible work. The amount of grassroots effort it takes for all of these groups, these community groups, right, for Fair Fight Action, for the ACLU, it goes on forever, Asian American Advancing Justice, all the groups, all the resources, all of the work, right? All of the Christmases and Hanukkahs everybody gave up last year to counteract these extreme acts of voter intimidation and suppression. Because some of those efforts are successful, right? Because we are able to, not in Georgia anymore, but in some other states, people can have water in line, right? Doesn't mean there still aren't really long lines, right? But in Georgia, in states other than Georgia, there's some states where people can be given water. That helps people stay in line. That doesn't mean they should have had a long line in the first place, right? We know long lines to be one of the most pervasive forms of voter suppression that exists throughout the country. And so I just want us to remember that just because there's some Band-Aids in places, that doesn't mean the fundamental principles have been changed. And as Reverend Woodall said, this is a country that benefits when everyone's at the table, right? When we have all of the talents, all of the voices, everyone participating. And so it really is an example of where, the injustice anywhere is a threat to justice everywhere. It really affects all of us when any of us are suppressed.
And if I could just add to that, when we saw, the historic nature of this last electoral cycle, we saw tens of thousands of registered voters, right? Duly registered voters being challenged 2 days, 5 days before an election. We saw elected officials, and not just last year, but former years prior, elected officials, Black elected officials in communities throughout this state, literally being locked up and charged with crimes for trying to get their people to vote. We had 5 elected officials in a small town in Southeast Georgia or in Southwest Georgia. We had one young lady who's worked every single cycle. She got charged again last cycle. She said, I'm not going to stop because this is too important to sit on the sidelines. We had people being challenged, and then you would have investigations, and the Secretary of State, Brad Raffensperger, sending investigators to voters' homes. And not just African Americans, but you have Hispanic communities in which have a natural distrust, because you have folks going all over the place saying, we're going to lock you up, or we're going to send ICE to your home. Those kinds of things, you talk about voter intimidation, is real. And so when we talk through how Shelby v. Holder has an impact, it's not just the laws themselves, it's people's lives. Challenging the very fact that people can participate simply because they may not vote like you, or may not agree with the way you show up in the world and the way you address and embrace your agency as a human being. These are real things. We saw communities being challenged by white supremacists and nationalist organizations. We saw militias organizing, at least even to Republican legislators and public officials. And so we've reached a point where the polarization is real, one, but two, so is the violence. And so what we have tried to do in Georgia was successful in building collaborative effort and coalition of organizations, to which Allegra spoke to, that we're not only able to talk about the legislative proposals and how to address those, but how to keep our community safe. And that is why I call it an urgent moment for us, because that is literally where we are at. We saw January 6th, at the nation's capital and state capitals all over the nation, going on lockdown, and the National Guard all throughout the country. And so we have really reached a nexus point, if you will, that requires of us to be creative in how we address these problems, but also to come together and talk through what we can do to make it through this moment as well.
That's a really excellent point. And I wanted to just pull up, kind of following up on that, just since 2021, there have been 18 states that have enacted or are in the process of enacting laws that restrict the access to vote. And I know Georgia passed SB 202, and I wonder if you could speak to that a bit, Reverend Woodall. And I mean, not to just point at Georgia, because obviously we have other states, but Georgia somehow has become this tip of the spear on these issues. And I'm wondering if you could speak to some of the things that are in SB 202 that are going to restrict the ability to vote.
Most definitely. And one, I'll start by saying that we saw during this last legislative campaign cycle, if you will, that there was hundreds and hundreds of legislative proposals throughout the country. Georgia saw about 60 to 70 of those. But what we had in Senate Bill 202, and we called it the new Jim Crow. And here's why. It's because when we look at the Black codes in Jim Crow of the 60s, the 50s and the 60s, they were using, in the words of one of the justices in the Shelby decision, not the Shelby decision, but they use it with surgical precision. I heard Celeste, you use that language. And some of the changes that we saw was to absentee and vote by mail voting. We said instead of returning an application by the Friday before an election day, it backed it up 2 weeks prior, or counties no longer being able to mail out absentee ballots until about 3 weeks later than they usually would do so. Changes to the runoff period. Instead of having it 9 weeks, they're now in 30 days, which is nearly impossible. We saw counties saying, hey, we cannot even certify our election and be able to reprogram our computer machines to be able to be prepared in nearly the 9 weeks. And so you making it into this 30-day process. You also saw under this new law, election officers no longer would directly receive funding. We saw a lot of these boards of election and registration going out and seeking third-party funding to be able to fund some of these things around the pandemic. And now under this new law, these counties are no longer able to do so, but instead it all goes to the state, and the state, quote unquote, will distribute those equitably. And what that means is some of the counties that were able to receive majority of the funding because they have the majority of the voters would no longer receive the equitable funding. And instead it would go to some of these communities that are less likely to need the extra funding because they don't have as many voters. We look at the state election board, which was one of the most egregious. Everybody talked, Allegra talked about it, and everybody in the media talked about the water and the food and the snacks. But one of the most egregious, if not the most egregious, was the state election board's powers being changed and given the board, only by extension, the legislature, more power to intervene in county election boards that are deemed unperforming. We see this in practice right now, where the Secretary of State, the elected representative, the person who is charged and duly elected to be able to handle the state's elections process, is now attacking Fulton County, which is the largest county in the state, or one of the largest counties in the state, has overwhelming majority of our voters. And, you know, they have now elected a new chairperson, and that the state's election supervisor, the chief election administrator, is now attacking this board because he didn't agree with who that chair should be. And so now he says he's going to use his powers, which I don't believe he has, but he's going to use his powers under this new law to literally suspend the whole board, all because she worked and was a lobbyist and had contractual relationship with Fair Fight Action specifically. And so when we look at how this legislation has been used, it's literally being weaponized by people who only want to see their kind of, you know, party or their kind of agenda being played out in public policy. And if you challenge that in any way, you saw the census numbers, we got redistricting coming up. If you challenge that, they're saying that now you are possibly committing voter fraud. Those are red herrings and dog whistles that we've seen before, suggesting that, you know, whenever African Americans or Hispanics or, you know, other communities, Asian American communities show up in large numbers, we had record turnout during this last election cycle, and now all of a sudden there's a concern that maybe there's voter integrity questions or voter concerns of fraud, which, by the way, we saw tens of thousands of complaints and those kind of reports, but I don't recall a single court, not a single one out of the hundreds that we saw, not a single one found any legitimate cause to say that there was voter fraud in this election.
I think that's a really important point, Reverend Woodall, because look, I think everybody here agrees we want free and fair elections, and we don't want fraud in our elections. And a lot of these laws are being proposed in the name of trying to weed out fraud in the electoral process. And I don't know, Allegra, do you have any thoughts on that, or Reverend Woodall?
I will just add to what Reverend Woodall said that, you know, there have been numerous experts that have found it is more likely to have someone hit by lightning than to find an actual instance of voter fraud. It's just not a problem. This is a solution in search of a problem, and I would suggest is just an excuse that's being used without actual evidence of any real concern.
So one of the things that the Voting Rights has is the Voting Rights Act has is not just Section 5, which is this pre-clearance, but it also has a provision under Section 2 of the Voting Rights Act where either the government, the US government, or a private individual who's affected can bring a lawsuit to challenge a discriminatory practice or voting practice. And I know this is something specifically that Justice Roberts pointed to as, look, you still have Section 2 claims. And Allegra, I just wanted to see if you could speak to, you know, Section 2 claims and whether they are a replacement for a Section 5 preclearance.
So look, Section 2 claims are different, right? So the DOJ had particular expertise in looking at the federal landscape and how proposed laws would impact voters. So this is different, right? This is different. Section 2 is also incredibly important. And so if they were redundant, we wouldn't have both, right? There are individual rights that really have been provided. And Section 2 is going to obviously remain very important, albeit altered, given the Supreme Court's recent decision in the Bronovich case.
And that is the second important
I
Supreme
can talk
Court.
about Bronovich now if you'd
Yeah,
like.
yeah. Yes, we can talk about Bronovich right now. That just happened this summer. Take it away.
Correct. So Section 2 was taken up in a series of various cases that were consolidated in the Supreme Court this summer in the Bronovich case. And what the Bronovich case really looks at is what quantum of proof is necessary for the court when it is ruling on these Section 2 claims. So, we have all of this evidence that we gather as part of our process. Fair Fight Action, for example, has an extensive declaration collection process when we hear from voters who have problems. And that is a big part of what the civil rights groups do. And so the question is, when we get to the courts, what is required? And what the Bronovich decision says is that there's not a specific test to govern all Section 2 claims, but the court set forth some new guideposts for the lower courts to consider. It remains to be seen, because that decision is so recent, how the lower courts will interpret those guideposts. And we really, if there's anything we'd like to flag for you is something very important to watch, it is this issue as it's interpreted. And I know Reverend Woodall, I should say this is an issue in our case. And so I'm obviously going to be careful not to talk about pending litigation, but it is incredibly important.
Yes, and Reverend Woodall, I know that you've been a named plaintiff in some of these actions, and the NAACP has brought some Section 2 actions, including, I believe it was the North Carolina case we talked about earlier. So if you wanted to talk about the importance of Section 2.
Most definitely, and we too have a pending lawsuit before the court, the federal courts, challenging the constitutionality under Section 2 of the Civil Rights Act of 1965. But I'm also personally non-affiliated, a named plaintiff in the Rose v. Raffensperger matter, which challenges the at-large nature of our Public Service Commission, which is another kind of aspect of voting rights where we talk about representation and equitable representation therein. And so one of the things that I've learned, and I'm no lawyer or an attorney, but being able to have these conversations has been important for me to understand the nuance of the benchmarks and the standards that we are trying to hold these pieces of legislation against. Is a matter in 1986 called Thornburg v. Jingles. And that is centered to the way we are able to challenge. And so understanding how racial and minority groups can appeal themselves into a district, and the voting strength of that population, and whether or not they're politically cohesive, right? Or are we able to operate and vote as a block? Those kinds of standards are being used to Allegra's point. The Bronovich decision really challenges that, and it's one that you have to kind of wait to see how it plays out. And I'm not necessarily too optimistic, but at the same time, I'm still kind of holding out and hoping we do the right thing as a country. So that's really all I have on that point. But ultimately, what we want to see is that every single community is represented in an equitable fashion, and these are what all these protections are all about. Because when you're able to say, I have, we talk about the census data that just was released, when you have a decreasing majority and an increasing minority, what does that look like for representation? Simply saying I have the most African Americans in a state legislature in the country, as Georgia does, is not sufficient. When you have the level of gerrymandered districts in that state, in which there is no competitive edge, there's really no ability for us to be able to hold our elected officials accountable, regardless if they're Democrat or Republican. And so that becomes a problem for so many of us, especially millennials, because young people are really saying, well, if they're going to just do what they want to do, what value is it for me to show up and vote? And so that's why I'm fighting to, every single day to ensure that we can have that accountability, because I don't want to just vote for somebody because they're Republican or because they're Democrat. I want them to be responding to the community that they represent. And if they cannot do that, then that is not democracy.
Yeah, and you mentioned the 2020 census, and some of these shrinking congressional delegations and some growing. And that's going to lead to redistricting. And this will be the very first redistricting under a census after Shelby. So with the, I'd say, guardrails, or as Justice Ginsburg called it, the umbrella that protects you from the rain. And I'm going to let Labor speak to that in a minute. But so this is going to be the first time. So this is an issue that I think we can all agree redistricting needs to be on everybody's mind. This is an immediate issue for voting rights.
Well, and Celeste, I just want to piggyback on something Reverend Woodall just said, because I've spent so much time listening to millennial voters. This is such an important issue. Absolutely, we know that as a generation, millennial voters want elected officials who are responsive. And gerrymandering goes directly to the heart of that. The number of voters who have told me, I didn't go to the polls, right? I sat it out because I didn't think it mattered. I didn't think I could make a difference in that. I didn't think there was a big difference between the candidates, right? That feeling of a lack of power around it is a direct result of gerrymandering. Like that's, it's not close in time, so it's hard for people to see, but I just think it's important to flag that when you feel that your vote is powerless, it is very likely because some people 10 years prior got together and drew a map that disadvantaged you, right? And so it's incredibly important. Many of our listeners today are, of course, familiar with the term gerrymandering. You turn it on, you turn on the television and you hear it. It's this notion of really how these districts are drawn following a census. And the reason that redistricting is on everyone's radar right now, and why you can't turn on the news without hearing about it, is that gerrymandering has been used to dilute the vote of groups historically throughout our American history. And drawing these districts is incredibly important. Right now, we are going to be drawing them for the first time after preclearance. So remember, we had preclearance up until 2013. So as an example, in Texas, remember, whatever your issue is, you'll see it come out on the other side as a result of redistricting and gerrymandering, right? That's where people feel the impact. In Texas, the 2010 census allowed the Texas legislature to initiate a set of newly drawn boundaries for the voting districts in the state. But you know what? It was 2010 and we still had Shelby County. And so what happened? The DOJ intervened and argued that the new maps adversely impacted the voting rights of both Latino voters and African-American voters. So Black and brown voters would have been disadvantaged, the United States DOJ argued, if those maps had been implemented. As a result, the court would not grant Texas the ability to institute those new maps, and better maps were instituted instead, maps that were not as suppressive. Obviously, they were not ideal, but they were not as bad as the ones that were rolled out. Well, that was 2010. That was under Shelby County, before Shelby County was decided. Post 2010, as in 2021, right, 2022, post Shelby County's decision in 2013, that stuff, it doesn't exist, right? There's no more pre-clearance for those types of redistricting decisions. And so we all have to pay very special and close attention to what happens when now that barrier has been removed. We're going to see in states across the country redistricting maps that are going to be highly problematic. That is our prediction.
And that's like things like squeezing all the minorities into one district where they may have across districts in different elections. And I just wanted to, go ahead, Reverend.
Yeah, I wanted to just, while we're still on this question, because it's important that when we're talking about Section 2 and Section 5 of the VRA, is that it addresses the racially polarized part of this. And when we talk about redistricting, racial gerrymandering is unconstitutional. It's been determined time and time again. But in 2019, as a part of the Rucho v. Common Cause matter, the Supreme Court basically said, well, partisan redistricting is out of our jurisdiction. We can't determine whether or not that this is something that we should be doing. And so they put it back in the hands of the Congress, right? And so it becomes for us, on the local and the state and federal level, is to be able to find ways to be able to engage in impartial and independent redistricting processes. And one of the ways that we have seen that is states are enacting these commissions that they are able to then take it out of the hands of political parties, but then be able to put, well, what makes sense? I know the Princeton gerrymandering project has these benchmarks that they're using to define what fair maps are. That is something that we oftentimes see, but we can't necessarily take it out of redistricting politics being the if you will, unless we are able to make it an independent process. And so we see legislation currently pending in the Senate that is being, hopefully is going to address this question of partisan redistricting, as well as some of these other concerns that we have as it relates to voting rights.
Well, that's a really important point, Reverend Woodall, because there is activity going on today, probably even today, specifically today, on the issue of voting rights, both in the House of Representatives and in the U.S. Senate. And I know, Allegra, you've been following this pretty closely. Can you just give the audience an idea of the laws that are being considered right now, or the proposed laws that are being considered right now?
So there are various laws being considered in different proposals. We just had the Freedom to Vote Act introduced in the Senate. The John Lewis Voting Rights Act amendments recently passed the House of Representatives. This legislation would restore preclearance, would update the test to determine which states have to go through preclearance. It would also provide more guidance on what constitutes discrimination, really to buttress what the Supreme Court has set forth as the guidepost in the Bronovich decision that we told you about. There are also some interesting and important provisions around campaign finance laws to make contributions more transparent. Another area we haven't had time to talk much about today, but that you feel in terms of the power of your vote later on down the road. So really important legislation that I hope that everyone is paying attention to. One of the things that we have seen a lot of energy put behind is, you'll remember I said earlier that Shelby County came about because the court said there wasn't enough in the congressional record to show that Black and brown voters were experiencing disenfranchisement. So a lot of effort has been put at this juncture into making sure the record exists. And Reverend Woodall and I talk to these voters all the time, so we know what's been important is to make sure that those records get submitted to Congress. And I would just remind all of our listeners that if you have ever had your vote suppressed, that's a story we need to hear, because that's a story we want Congress to hear. You can, Celeste, can I do this? You can always send it to story@fairfightaction.com. story@fairfightaction.com. We will take your story and make sure that it gets recorded and that we honor your experience in that way, and make sure that history understands what has occurred, so that we can chart a better history for our country, a better future for our country.
All of this and charting a better future for our country is so important. And so I want to thank all of the panelists for the comments today. There is no doubt the right to vote is a fundamental right that we all must care deeply about. The entire notion of our American democracy, the idea that we, the people, electing our representatives to run our government, hinges on the citizenry having the right to vote. And so as we close out the panel today, I invite our panelists to offer their closing thoughts on where you think the right to vote is headed in the future. Most of our participants today range from college students to law students, but there are a few of us who are professors and practitioners that might be in an older age category than our students. But in closing, what do you have to offer? What are your thoughts? I'll start with Reverend Woodall. What are your thoughts, and what imparting advice do you want to leave for our students as they may vote for the very first time in a soon-to-be election?
Well, one, Dean Richardson, thank you for that, and thank you for your work that you do at the law school. My closing thoughts are this: I struggle with whether or not I want to give you hope or do I want to give you the truth. That's what my grandmother would say. God rest her soul. The hope is that our power, our collective ability to be able to stand together, that we, the people, the most important word in this thing called democracy is still intact. That when we show up to the voting booth, and when we go to church, and when we go to grandma's and grandpa's house to be able to have that fried chicken that we want on Sunday after church, that is what America was supposed to be. That's what America is, and that's what ultimately she can be if we continue to do the work that our souls must have, in the words of Dr. Katie Geneva Cannon. But the truth is that we are facing some of the most vile, cruel, and unusual circumstances that many of our ancestors did experience. And so it is up to us to do that which others claim cannot be done. It's to defeat evil. It's to ensure that our children and our children's children, and the Constitution calls that its posterity, they are able to live in a world where we can be free, that we can believe that difficulty can lead to deliverance, that we won't give up and give in to the evil ethics of drunk politicians, drunk with power, but really wake up every single day and say, I love this nation too much to let our people give up on her dreams and her hope that we can live in a better world. That is what that promise is all about. And it's deeper than voting. Voting is the bare minimum of what it means to be an American citizen. And if we cannot get that, then America can never truly be who she's been called to be. And so I'll leave you with that thought, that if we can get this right, then we can start talking about some of the more complex, and voting rights is complex in and of itself. But if we can't get that part right, then I'm really afraid that we can't get any of it right. And so I leave you, and I thank you for the work that you have done, that you will do, and that you are doing in the name of freedom, liberation, justice, and peace for all people. Thank you so much.
Celeste, you have had the chance to play moderator most of the hour, but I'll turn to you to offer your thoughts. Are you going the way of hope? Are you going the way of truth? Are you going in a different path for what to offer our students in the future?
So I have children, so I am going to go in the way of hope because that's what I need to believe. And it's really important that we're talking to this community, because young voters make a difference. In the 2020 election, young voter turnout was 50%. That was historic compared to the 2016 election, where that turnout was 36%. And you can see that made a difference. And the other thing I just want to say to young voters is that the very laws, these laws that open up the access to voting and make voting easy and less restrictive, the researchers have associated that with actually an increase in young voter turnout. So if we have less restrictive laws and our ability to get there and get young people there and voting, then we're going to have more young voters. And look, they're the ones who are going to have to deal with climate change. They're the ones who going to have to deal with these very important issues.
Allegra, you have the last word. What message do you leave our students?
I wish that we were in person, because if we were all together, my optimism would be fueled by all of the millennial and Gen Z voters in the room. Whenever I give one of these talks, I always end on a high note, because people show up. The fact that people logged in today, right, when they could be doing anything with their Friday afternoon, and they're still with us now, means this world is going to get to where she belongs, right? We are headed there. And, in the words of one of my favorite presidents, we are the change we seek, right? It's just us. It's just us. And the people who are here today will be the people who run for office, will be the people who encourage their friends to run, who support, who knock doors, who vote themselves, have a plan for voting, who make sure that every friend and family member and person in their church is voting as well, right? All of us together will be the change we seek. I want to remind us, nothing partisan about this, right? President Nixon renewed the VRA, President Ford, President Reagan, President Bush, all of these incredible leaders in our country have recognized the importance of voting rights, and we are the people who every day work to enforce them. So thank you so much for your incredible work, as Reverend Woodall said that you have done, and that you will do, and that we'll all do together.
Well, thank you all so much. Thank you, Reverend Woodall. Thank you, Celeste. Thank you, Allegra, for sharing your time with us today and for all that you do to ensure that everyone has the right to vote. Thank you to all of our participants in today's Constitution Day program. September 17th, Constitution Day, always remains one of my favorite days of the year because we have the opportunity to talk about these rights that are so important to everyone in our country. So thank you very much. Thank you for sharing your afternoon with us.
Thank you, Dean Richardson.